everyone. Thank you all for being here. I'm going to get us started just to give you a quick overview of what we're going to talk about today. So I'm going to go over our roadmap slide. So we're going to start, and I'm going to start with just a quick overview of the first appearance process in juvenile court. I know many of you do adult work, and this may be somewhat of a review for a lot of you, but I'll give you a brief overview of the first appearance process. And then we'll talk about the different stages of the case after the first appearance. And so if you are taking a first-degree murder case, what to expect after that. And then other important topics related to first appearance. And we'll save some time at the end for questions. But if you think of a question, as Eric said, please feel free to put it in the chat and we will monitor the chat. So what happens before the first appearance? First, you have to get appointed to a case, of course. This slide comes from just our work in the field. How do you know that you've been appointed to a first-degree murder case? It essentially varies by county and somewhat varies by delivery defense system. But generally, the clerk will contact attorneys to inform them that they've been appointed. In some counties where there are public defender's office, public defenders will appoint after they receive notification from the clerk or the juvenile court counselor. But this slide is just up here to kind of remind you that you will get appointed through one of these ways. As our office starts to take on first-degree murder cases, you will get notified by us, but right now it's the clerk or in some counties, the public defender. Okay, so before the first appearance, it's important, if you can, to locate your client. For these first-degree murder cases, most of our clients are going to be in secure custody. And so we wanted to include this slide just to let you know how to locate your clients. There are 14 juvenile detention facilities in the state, 10 operated by DJJ, and 4 that are county operated. So for example, if you live in Durham, the Durham County one is county operated, and out here where I'm at in Asheville, the one closest to us is in Madison and is also county operated. But just to think about it, if you're able to visit your client before the first appearance, it's helpful because as you'll find out, usually you'll have that initial secure custody hearing right at the same time. And it's just important to get as much information about the client as you can. Probably the easiest way to figure out where your client is, though, is to contact your court counselor or DJJ in your region. They'll be the one who knows. Juveniles are usually housed in the facility closest to their county, but if there is not bed capacity, they could have been moved. So just contact your court counselor to be sure. So this is kind of the meat of what a first appearance is in juvenile court. You can find it in 7B 1808. And the statute really says that all youth charged with a felony offense are entitled to a first appearance. If your client is not in custody, that first appearance must be held within 10 days of the filing of the petition. It can be continued for good cause, but again, that's only for clients that are out of custody. If your client is in custody, in secure custody, which will be most of our clients with first-degree murder, that first appearance is going to be held at the initial secure custody hearing that's required by 7B 1906. So what are the requirements for a first appearance? Again, this is found in 7B 1808. And if you do adult work, it will look very similar, except there's probably one addition that I'll point out. But during the first appearance, the court must inform the youth of the allegations set forth in the petition. They also have to determine whether the youth has counsel, retained, or appointed. This is that in some counties and jurisdictions, this is where you or the court will confirm that you've been appointed to the case. If applicable, inform the youth of the probable cause hearing date. So the statute says that for youth charged with a felony, they have to have a probable cause hearing within 15 days of the first appearance. There are some exceptions to this for 16 and 17-year-olds. 16 and 17-year-olds charged with A through E felonies can have a probable cause with a date set within 90 days. But they will inform the youth of that hearing date at the first appearance. And the difference between adult court and juvenile court is that one of the differences is that the court must also inform the parent, guardian, custodian of their responsibility to attend all hearings. That was something that wouldn't happen in the first appearance for adult court. If you for some reason you have not been appointed officially before the first appearance, the court will appoint you or other counsel in accordance with IDS rules. So what is your role as the appointed attorney or the attorney at the first appearance? Essentially, it's again very similar to the role in adult court. Ensure that the court informs the youth of all the allegations, confirm that the court knows that you're appointed. As we said, make sure the probable cause hearing date is set within 15 days of the first appearance, 90 days for youth 16 and 17 charged with A through E felonies. And if your client is in secure custody, be prepared to argue and represent them at the initial secure custody hearing. We'll talk a little bit more about secure custody a little further along in the presentation and some of the secure custody factors. But as we kind of emphasized earlier, locating your client, hopefully talking to them will prepare you for both the first appearance and the secure custody hearing. I think that's all for that slide. Again, just to point out the parent and guardians at first appearance. So the parent and guardian or custodian must be present at the first appearance. At the first appearance, the court advises the parent, guardian, custodian of all their responsibility to be present at all hearings. And the court also would inform the parents that they could be held in contempt if they do not attend the hearings. So again, a difference from adult and juvenile court. Once the case is transferred to adult court, that responsibility of the parent, it doesn't attach anymore. But while they're in juvenile court and while the hearings are in juvenile court, the parents must be present and must attend all hearings.
Thanks, Yolanda. So let's talk a little bit about the timeline, starting from when the petition is filed to when these sort of combined hearings of a first appearance in secure custody. And when I say combined, it's because specifically for these first-degree murder cases, it's highly, highly likely your client will also be in secure custody in the process of going through these procedures. So a petition is filed. The first appearance is held within 10 days of filing the petition. And I believe that is 10 calendar days. If it falls on a weekend, it would be the next day. But it's supposed to be held within 10 days of filing the petition. The first appearance can't be continued for good cause if the juvenile is in custody. So again, the likelihood is your client would be picked up and you'd have a secure custody hearing within 5 days. And then the first appearance hearing within 10 days of the filing of the petition. I don't know that there's necessarily any remedy if these timelines aren't completely followed, but you might want to just consider the strategy there. It might be there's a reason you want to push for first appearance quickly, but there may be a reason why you're not so interested in making that happen. As was noted earlier, because of Raise the Age, we do have some differences in some of these time frames and timelines. So probable cause is supposed to happen within 15 days of first appearance for 13, 14, and 15-year-olds. And then probable cause is supposed to happen within 90 days for 16 and 17-year-olds. Now, again, backing up to the first-degree murder specifics, note that in just the last legislative session, so for crimes committed on or after December 1st of 2023, continued secure custody hearings are now held every 30 days for 13, 14, and 15-year-olds. So I'm just pointing that out in case there's any confusion. So that first appearance date was not impacted by the law that changed the secure custody review of secure custody hearings from 10 days to 30. I hope I'm not making things more complicated by pointing that out, but I think it's just worth mentioning in case there's some confusion. And again, because it's in all likelihood, your client will be in secure custody while the first appearance hearing will be set on the calendar. So, of course, as a result of the pandemic, there was a new law passed that described what are the rules around virtual and in-person. And as you can see here, that you can use audio and video transmission, which can be in various forms. And I know I've observed this in court, um, generally for hearings that don't involve interfering with due process. And so what we've observed is largely for secure custody hearings, this is happening. I don't know that I've specifically myself witnessed first appearance handled virtually. Let me just ask everyone, and you can throw it in the chat or you can jump out and just make a comment. Are you all seeing first appearance hearings, not just secure custody, but like first appearance hearings happening virtually? Anybody have any experience with that? Okay, Julie says yes. Anyone
In
else?
Brunswick County, we have done, I'm sorry, I didn't mean to interrupt.
Go ahead.
In Brunswick County, we have set up WebEx to do first appearance on a rare occasion if it's the child is sick or some that the facility has some issues. Typically they get them there, but we've had first appearances on WebEx.
Okay. Okay. So as you can see in the next paragraph, you know, if due process rights are being sort of implemented here, you have the ability to say, no, we don't want that. We want to have it live. Anyone have any thoughts about that? Why you might want to have the first appearance in person versus virtual? Any thoughts?
I absolutely do. I just had one about 3 weeks ago that was automatic, going to have to be a transfer, but I still just want my client needs to sit there and talk to me. He's still a child, even though he's 17. And it, for one, I think it's comforting to the child. And then also, if I need to hear, I can't talk to him or have him whisper anything to me if he's in online, and anything he might jump out and say online, I can't stop when it's already said.
Thanks. And I see, yeah, I see Tim also was commenting too that it's live. So yeah, I mean, I think we always have the ability to at least motion it on for in person. So you should really consider doing that if you think it helps your client or otherwise helps the case.
I have a question about that. So, because I always object and want it in person. Unfortunately, where we are in Forsyth County, most of our kids are being held in Madison County, which, by the way, from Winston, if you go to Asheville and take a right, you just keep going until you almost hit Tennessee. You know, they, even with court orders to have the children brought in person, DJJ Transport doesn't. I mean, even my juvenile hearing this morning in Superior Court for a kid charged with murder, they didn't have him there. They might not have my 230 there. So what kind of order do we need for that transport? Because we've had court orders for them to be transported and nobody cares.
Well, I've got a couple thoughts and I'd like others to jump in. As best you can, and I realize with like a first appearance hearing, it's very difficult. But if you have information that your client is out there in Madison County, and for those of you who may not know, Madison has been holding a lot of the kids charged with the most serious offenses and are being bound over. That, as Julie just described, it's way out in Western North Carolina. But as soon as you can, not only inform the court, but the chief court counselor of this, and even possibly, sending an email or calling the detention center and letting them know ahead of time. I think the more people you can put on notice, the more likely it is to be happening. Any other thoughts about that from anyone else who's had success? So I'm reading, I'm sorry.
Oh, Victoria, I've actually tried that. And so part of our problem is that our clerks have managed to mess up our orders repeatedly. for about 2 years. So when I get our continuance orders and things like that, I literally have to email every day for them to correct them and include that in there, that they are specifically ordered to be brought in. So we have 2 judges that will actually do a show cause. But then the question is, who do you hold in contempt? Because it's not the facility, it's DJJ that does the transport. So, so I'm more than happy to do show causes. Just ask Eric. I just don't know who to ask for it against.
Well, and one thing we can do is, we've thought about this specifically in terms of the first-degree murder cases, is work with DJJ on greater access to attorneys with their clients, and this would be one of those things. As we're getting closer to actually activating the roster, we've got this on our list now, and so we'll talk to them about that and how to make it easier to transport them. So thanks for letting us know, Julie. So I think it sort of has been pointed out, there's some pluses and minuses, mostly pluses of why your client should be in person and not virtual. I mean, again, as Julie just described, it could be difficult to physically get out and visit your client. And so getting them into court is one more sort of in-person contact that you have with them. And as I have witnessed in some courtrooms, sometimes the system works quite well and you can hear clearly, and attorneys have the ability to connect with their client confidentially, but there's other places where this doesn't happen. And some clients, may not, want to travel across the state to be in person. I don't know. So you talk to them about it. But I think, as has been mentioned in this discussion, it's much more likely that it's going to be helpful. So once first appearance is over, if your juvenile goes back to secure custody, then, and this is specifically for first-degree murder cases, then the secure custody hearings now are automatically every 30 days. Remember that I mentioned that now 13, 14, and 15-year-olds charged with first-degree murder for offenses committed just after December 1st are now also in this grouping. It's 30 days, but you can always request a 10-day hearing. Again, this may or may not go back to the virtual versus in person, but the statute says if the council requests it, then it should happen. So hopefully you don't have any problems with that. At this point, the state might already be seeking an indictment, or they could request a date for probable cause. We, of course, know since Raise the Age was implemented, it's very, very much going by indictment. There are not a lot of probable cause hearings, even though folks are asking for them, or for some other reason. But anyway, we know there's mostly indictments out there. And what's frustrating about that, of course, is that while there's the 90-day window for first appearance for the 16 and 17-year-olds, there is no window for indictment. And we, of course, also know that grand juries meet at different intervals in different places. So that can be frustrating. So something else happened last session, and as you can see in this transfer portion, you can see that notice to the transfer is now occurring if there's notice to the juvenile and a finding by the court that indictment has been returned, or notice hearing and finding of a PC about a Class A offense. It's that first bullet that's now gotten a little confusing. I think in most cases, you're still following the process that was before, which is a grand jury handouts an indictment. Notice is brought to the court either directly or by the prosecutor. And then you do have a hearing, which would include the judge saying, well, a true bill has been approved by the grand jury, and we are now transferring you, and now we are going to pretrial confinement, discussing that sort of thing. And I know we're specifically talking about a first appearance, but I just wanted to mention that it seems like these hearings are still going on. We don't know if that's going to be forever in the statute, but you should still be having some sort of in-person discussion that, yes, in fact, there was a true bill and now your client is being transferred. So I think for a lot of these youth, what is the hardest thing, both emotionally and intellectually, to come to grips with is the front end can be really, really fast. And then there's a lot of wait time. And so sometimes I think they've got a lot of questions. They don't know what just happened because it was so quickly. So, like I think we're mentioning throughout this discussion, it's really important to stay in contact with your client. Whether that's visiting them in person if you can, whether that's sending them a letter, whether that's calling them, whether that's having a video conference, consistent contact is very, very important. Um, in fact, we had the UNC School of Government had their intensive training last week, and we visited the Guilford County Detention Center, and I think we were all reminded of this, how important it is to stay in contact with your client. Continue to negotiate with the state if such a thing is happening. Seeing where the prosecutor is at after first appearance. Start your investigations. Begin by requesting records. I just talked to an attorney yesterday who was really on top of this about what kind of records and how to get them. That's a presentation for another day, but get as much information as you can as early as you can. If you have a probable cause hearing coming up, start planning for it. Start figuring out, what do you think the state's case is going to be? Whether or not you're going to put on evidence, what you can anticipate. There was also a presentation last week on probable cause, and one of the takeaways was make sure it's recorded. It doesn't necessarily have to be, so either ask for it to be recorded, or like we were discussing, bring a phone or some sort or other kind of recording device and make sure it's recorded. That kind of thing. Start thinking about PC. It's also, I think, important to maintain contact with the parent, guardian, or custodian, at least just saying, hey, nothing has happened, or we're waiting on something. As you can imagine, our office does get calls sometimes about, well, I haven't heard anything, and we try to explain, well, nothing has happened, likely. But I think it helps with the entire representation, as your client's parent, guardian, custodian are going to influence your client's decision. And so I think staying in contact kind of helps those sort of communications to a point, but maintaining some contact with them, I think, is helpful. As was discussed, I hope everybody knows that, again, from the raise the age sort of set of laws, if you are under 18, you are going to be held in a juvenile detention center. Yolanda had a list of those. I put up the link as well, because it's subject to change. Rockingham County, Perquimans, and Richmond County should all be up and running by the end of this year. And as these things change, you can contact us, but that's the link that's usually pretty well updated in case you have a question. But was like discussed earlier, if you're having trouble, contact us, or contact DJJ, and they should be able to tell you, where your client is being held. I sort of already touched on this before. It's just sort of a reminder that get with your client, find out where your client is, get with your client, and keep in touch as best possible. So right now, like with generally most other representation, unless you have a contract, when you're representing the youth at first appearance, submit a fee app. That's how you're going to be paid. Our plan is that once the roster is up and going, we will have a centralized payment process where payments can be made to IDS on an interim basis, so folks can be paid quicker and more regularly for their representation. We're still kind of working on a plan for direct payments, but we will let everybody know who has been approved for the roster how that's going to work. We're going to give you plenty of time, and we are also planning to have a training on that. So there will be resources on how to do that. And with that, I hand it over to Terri Johnson.
With you, some other topics that frequently come into play with first appearances, one of which is valid service. You show up to court and your client is not present or the parent's not present, then what do you do? So we're going to talk a little bit about that, and we'll also talk about secure custody hearings as well. So the first part of that is pleading, process, and service. Those are covered under 7B 1801 and the subsequent statute sections there. Eric, if you can advance the slides for me. So the overview of this is 7B 1801. The petition is the pleading. Process is the summons. We need to go forward one more slide. Under 7B 1802, the petition has to contain certain statutory criteria, those being the juvenile's name, the date of birth, their address, last known address of the parent, guardian, or custodian, and a plain and concise statement asserting facts supporting the criminal offense and the juvenile's commission. One piece to be aware of here is that sometimes at that first appearance, DAs like to ask to amend the petitions. We'll talk about that a little bit later in the presentation, but just put a pin in it for now and be aware that's something that might happen. 7B 1805 is very strict and says that immediately after a petition has been filed, the clerk shall issue a summons to the juvenile, the parent, guardian, or custodian, requiring them to appear for a hearing at the time and place listed on the summons. And we put a copy of the summons here. One thing that has been argued pretty extensively, at least in my district, is what immediately after the petition has been filed means, because we have had youth be placed in custody on secure custody orders, and they have not been necessarily served immediately with the petition and the summons. That typically happens whenever you have a child who is picked up overnight on a Friday or on a weekend and the clerk's not available, so they don't actually get served until they're brought into court for that secure custody hearing, or at some point early Monday morning before they've actually been brought to court, but certainly after they've been in custody for several days. You do want to check to see if your summons is accurate and if the petition was timely filed. 7B 1703 talks about petitions needing to be filed within 30 days, 15 days with an additional 15-day extension for purposes of juvenile court counselors and when they receive the complaint. There's a number of cases on this point that say that the court counselors not filing within 30 days is no longer considered jurisdictional, but you may still have some arguments to assist your client if that hasn't been followed. So then that brings us to service of summons under 7B 1806. Summons and petitions shall be personally served on the parent, guardian, custodian, and the juvenile. Law enforcement officers forget this all the time, and they serve just the parent, and they'll hand them both copies, one for the child, one for the parent, and mark that they've served everybody when they have not. So you need to double check and make sure your client has actually received their copy of their paperwork. Service shall be made not less than 5 days prior to the date of the scheduled hearing, and a law enforcement officer or a juvenile court counselor may serve. So General Statute 143B 831 provides some documentation on this and some additional information. Court counselors sometimes think they can't serve, and in areas where they have been told that they can and have suddenly realized that they can, sometimes they are not marking appropriate boxes. I've had a case recently where a court counselor served a petition on my client, but they didn't mark any paperwork that they had served the client, didn't mark a return of service, certainly didn't give anything back to the clerk. So I didn't have any verification that the child had been served. Make sure you're double checking those service boxes on the back of your petitions. That brings us up to the actual secure custody hearing. So as you've heard, if you are doing a first appearance and your client is in secure custody, those things are supposed to happen at the same time. First degree murder cases, it is unlikely that your child is not going to be in secure custody for those purposes. 7B 19000 all the way to 7B 1907 are your statutes for secure custody hearings, criteria, and the process itself. So I'm going to cover those a little bit, not as in detail as we have in some other presentations, but we're going to at least give you an overview here. Initial secure custody hearings are covered under 7B 1906D. That says the court shall receive testimony and allow the juvenile, parent, guardian, custodian an opportunity to be present and to provide evidence, examine witnesses, and be heard on their own behalf. So one piece of this that people tend to miss, judges tend to miss it, everybody's in a hurry, it's a first degree murder charge, people sort of walk in thinking, okay, we know what's going to happen here, this kid's going to stay in secure custody, and it gets rushed. Prosecutor stands up and starts reciting, here's what the evidence is. That is not a hearing. You need to be able to have the witnesses against the child present so that you can question them, that you can cross-examine them, so that the client can hear these things. And this is where some of the pieces that Eric was talking about earlier with your virtual hearings come into play, because if you're having an actual secure custody hearing and you're going to be questioning and cross-examining witnesses or presenting evidence on behalf of your child, they need to be present in the courtroom to be able to see that. And it's obviously very different if they're sitting in a detention center miles away looking at a computer screen versus being in the courtroom where they can lean over to you and ask questions or hand you a piece of paper to say, hey, that's not exactly accurate, this happened, maybe ask about that. So under that same statute, the court shall not be bound by the usual rules of evidence, but you do have another section that says the state shall bear the burden at every stage of the proceeding to provide clear and convincing evidence that restraints on the juvenile's liberty are necessary and that no less intrusive alternative will suffice. We're going to get to the statutory criteria in just a second, but generally speaking, we're going to be arguing pretty strongly on the no less intrusive alternative will suffice. So if you have a child who is charged with first degree murder, they're young, say they're 13 years old and they're sitting in custody for this, maybe that meets the statutory criteria and there's a reasonable factual basis, but there's a less intrusive alternative. There's a Bridges Assessment Center or another relative who's willing to take placement of the child. We need to remember that we can argue that, but it's also the state's burden to show that no less intrusive alternative will suffice. So if they haven't presented any evidence, here's an opportunity for you to make some argument. 7B 1903 sets out the criteria for secure custody, and I'm going to go through these pretty quickly, but for first degree murder purposes, there are 8 statutory criteria, and we are largely going to be looking at number 1, charged with a felony and has demonstrated that they are a danger to persons or property. Typically, if it's not one of the higher level felonies, A through D, you've got a pretty good argument that if your client has no prior record, they have not demonstrated that they are a danger to persons or property. DAs are going to flip that argument around when you're standing in the courtroom and your client is charged with one of the higher level assaults. If they're charged with a sex offense, they'll try to use the facts of the actual case to say, okay, but this is what happened in this case. So they've demonstrated on what has happened right now that they're a danger. But you can still argue that that's not the statutory criteria. This child has never been to court before, so they don't have a demonstrated pattern of behavior. Then we have a second one. Youth has demonstrated they are a danger to persons and property and are charged with either a misdemeanor that involves an assault, a misdemeanor in which the youth used, threatened to use, or displayed a firearm or a deadly weapon, or they are charged with an impaired driving offense. Those are all criteria for secure custody. We have several others. Again, we're going to go through these quickly because we're not focused on those for first-degree murder purposes, but those are that the youth willfully failed to appear on a pending delinquency charge, violation of probation, or post-release supervision. So looking at this one just very quickly, if your client missed the first court date and the parent has come to court and said, this kid has been difficult and, I just couldn't get him out of bed, I got served with the papers, they knew about this date, that's going to be a problem that you're going to have to work with. So you do need to be talking to parents, try to have some conversations with them about the impact of things that they're saying. I would also say for post-release supervision, if you are lucky enough to keep your client in juvenile court and they are committed to YDC on a first-degree murder charge, you may be handling these post-release issues as well. So you do need to be aware that this is a situation you could see later. Then we have delinquency charges pending, and there's a reasonable cause to believe the juvenile will not appear in court. That's typically going to be when you have a kid who has a bit of a history and they've not shown up for court dates in the past. I will say that I have had some clients who do not have court histories, but we have court counselors who say, well, we just don't think this child is going to show up to court because they've got a sibling or a friend who has also had difficulties with the court system, or they have a history of running away from home, or they've got truancy issues. That doesn't necessarily mean they're not going to show up in court. And then the last two that I've listed here, juvenile as an absconder from a detention or a residential facility operated by the division. Hopefully you don't have this come up. I have had at least 2 kids do this where they have escaped from a detention facility. They tend to not get out when you're arguing those secure custody hearings. It's very difficult when you're looking at a judge and saying, I want you to release my client to their parent. And I think that they'll be showing up for court dates when they climbed a fence and escaped from YDC. And then the remaining criteria deal with undisciplined youth or those with mental health needs. You're unlikely to see those in first-degree murder cases, but you may want to take a look at them just in case. If you're doing other juvenile cases, you certainly want to take a look at those and make sure that you're familiar with them. So that brings us up to court orders. So the court has a number of options at a secure custody hearing, and it never hurts to remind your judge that you have options. Secure custody is not something that you have to do. You can release this client on a written promise to appear. So parent, guardian, and custodian can sign paperwork saying, yep, we're going to bring them to court. Just the same way an adult in the adult system could sign their own written promise to appear. They can be released to a responsible person or organization. That could be a grandparent, an aunt, an uncle. I've had a client released to a neighbor who was a law enforcement officer who said, I'm willing to take on responsibility for making sure that this child makes it back and forth to court. They can be released and given conditions or restrictions that are related to securing their appearance in court. So house arrest, electronic monitoring, who's going to transport the child to and from court. There's a number of ways that you can get your kid out of secure custody, but still have some restrictions that satisfy the court that the child is going to be in court when they're supposed to be. They can be released on any other condition related to securing their presence in court. So I have had children that are ordered to cooperate with therapy, with Bridges Assessment Centers, to cooperate with placement with a relative who is not a parent. There have been cases where mom and dad are involved in the crime, or they are alleged to be a victim or a witness, and the child gets placed with a different relative. That person comes to court and says, I'm willing to be placed under the court order, and the court orders certain restrictions on that person as well. So those are some other ways where you can get your client out of secure custody. So the order itself has to be in writing with appropriate findings of fact. 7B 1906 is pretty specific on that point and states that the findings shall include the evidence relied upon in reaching the decision and the purposes which continued secure custody is to achieve. So again, secure custody hearings, they are hearings. Evidence is supposed to be presented, and the judge has to say what they relied on. And if your DA is the only person who spoke in the courtroom, then that order should say that the DA said, and list what the DA said, as opposed to we had a hearing and this officer testified, and based on this evidence, this is what I found. So make sure that you use that. If you're having difficulty with your judges saying, we just want a summary, make sure you use this piece as well. So that brings us up to time limits. We've already talked a little bit about time limits for first appearances being within 10 days of the filing of the petition, but secure custody also has its time limits. So no juvenile shall be held under a secure custody order for more than 5 calendar days without a hearing on the merits, and that hearing cannot be waived or continued. Push that issue. So if you have a kid who is in custody and you're looking at that time and everybody's saying we just don't have time to schedule this, you don't have the option to waive or continue that first hearing. It has to be done, and it has to be done within 5 days. For youth who are under 16 and not charged with first-degree murder, hearings on continued secure custody occur at intervals of no more than 10 days. Those hearings can be waived with the consent of the juvenile, but for no more than 30 days. And then we have our raise the age youth charged with the A through G felonies or 13 through 17 and charged with first-degree murder. Those hearing intervals are at 30 days. Also can be waived only with the consent of the juvenile, but you can ask for a hearing within 10 days. So even though the statutory language is 30 days, if the judge finds good cause and you have presented good cause, they can have those hearings within 10 days, even though we have this language now that says 30 days is allowed. So that brings us up to amendment of petitions. I told you we would reach this in just a little bit, so we're back to that issue. When you're at those first appearances, errors in petitions are often addressed right at that first appearance or initial secure custody hearing. 7B 2400 limits amendment of petitions and says that the court may permit a petition to be amended when the amendment does not change the nature of the offense alleged. And if a motion to amend is allowed, the court shall give a reasonable opportunity to prepare a defense to the amended allegations. So you can ask for a continuance, you can ask for additional time. You may not want to if your goal is to get your client out of secure custody. You may be more focused on that, but I would caution you to be careful of agreeing to amendments. If your provisional counsel especially, and you know that this case is going to be handed to somebody else and you're there to only do secure custody, I would be very careful about agreeing to an amendment of a petition. And there are certain things like if the back of a petition is not marked approved for filing, that's not something you can amend. That actually makes your petition defective. It would need to be dismissed and refiled. So again, make sure you know those rules, how those things interplay with each other, and know if you're going to be provisional counsel versus you're actually going to be appointed in the case, because there will be some differences with that. Restraint hearings are the other thing that coincide all the time with first appearances and secure custody hearings. They could be basically a presentation in and of itself. Restraint hearings are covered under 7B 2402.1. Read the statute, know where it is in the code, carry your code with you or have it available on your phone so that you can recite this to your judges, because it's very specific and presumption is in favor of restraints being removed. So it says specifically that at any hearing, the court may order physical restraints in the courtroom only when the judge finds the restraints are reasonably necessary to maintain order, prevent the juvenile's escape, or provide for the safety of the courtroom. It also says that the juvenile and the attorney shall be provided an opportunity to be heard to contest the use of restraints before the court orders the restraints. So I know in a lot of counties we see kids brought into the courtroom in shackles and they go ahead and have these hearings and the courtroom's open. Everybody's sitting there watching. Better practice would be to ask for that courtroom to be closed so that you are not having your client paraded into the courtroom shackled and chained in front of everyone before having this hearing. Better practice still, push your court counselors, your DA to read the statute and to understand that the presumption is removal of those restraints. Even in those most serious cases where a child is charged with first-degree murder, there's generally multiple officers in the courtroom, multiple court counselors. Unless your client is acting out and causing significant problems, it is rare that they need to be restrained in that courtroom. So you should always have those arguments. Don't stand in the courtroom with your client beside of you, looking at you, and a judge saying, "Are we removing the restraints?" And you pipe up and say, "It's not necessary. It's okay. Leave them shackled." I've had one case where a client wanted to come into a courtroom with shackles and chains on because their parent was the alleged victim, and they were mad, and they wanted their parents to see what they had done to them. That's an unusual set of circumstances. By and large, you need to be arguing for your client to have restraints removed at every single hearing. So I mentioned closing hearings. 7B2402 covers open hearings. It requires that hearings are open to the public, that they can be closed on motion of the party or the court's own motion, and the court is required to consider the nature of the allegations against the juvenile, age and maturity, benefit to the public and the juvenile of confidentiality, and the extent to which confidentiality of the juvenile's file will be compromised by an open hearing. No hearing shall be closed if the juvenile requests that it remain open. If shackles are being ordered, ask for that courtroom to be closed. If your client is charged with a sex offense or murder or some other serious offense, ask for the courtroom to be closed. I don't ever leave a courtroom open for even a first appearance if my client is charged with a sex offense. And I certainly wouldn't leave the courtroom open if they were charged with murder, because there are people from the community who are sitting in the courtroom listening to everything that is being said during those hearings. So unless your client says, "I really want this hearing open," you need to have a discussion with the child about the benefit and the cost of having an open courtroom when these things are being presented. And again, unless your client has some good reason why they want the courtroom open, you need to be arguing that it be closed. I see there's a question, but it disappeared too fast for me to read it.
Harriet says, was that somebody cutting in?
Yeah, I'm sorry. I didn't mean to interrupt. I was just going to explain my question. Go ahead.
Go ahead. Oh, go ahead, Victoria.
I've had a judge deny to close the courtroom in a sex offense case. It was not the actual hearing, but it's still, things are going to come up. It was Class C felony. It didn't end up getting transferred, but it still was sexually related things. Denied closing the courtroom. And I didn't know, is there any recourse that I would have at that point? I was trying to just look real quick at the time, couldn't find anything. Is there a way to appeal that at all? I mean, because obviously it's currently happening. Any suggestions?
So there's no remedy listed in the statute, but the statutory language is mandatory. It actually says shall be closed or shall be open if the juvenile requests that it be open. The language is a little different if they're requesting that it be closed, because the judge is allowed to consider these factors. The way I have gotten around that is getting the DA and the court counselors on board with me to do the case either last in the day or last right before a break, because then everybody's gone anyway. And I've only had one judge be problematic with this and say that they were going to deny closing it. And I just said, well, then we're not prepared to hear it at this point. And I had that conversation with the DA and said, let's just revisit this whenever it's closer to lunchtime or the end of the day. I realize it makes my client's parents have to wait, but it's better for my client to not have an open courtroom. So I've gotten around it that way. If anybody else knows of an actual remedy for this, I am open to suggestions, because as I said, I don't believe the statute provides any remedy if the court denies the request.
Tori,
Thank you so much.
one, contact David Andrews at the Office of the Appellate Defender. But in the meantime, you might want to either the next time you have a hearing with this case, or just separately ask that it be brought back on the calendar and ask that your objection be made in writing and made as part of the record, and then pretty much at every other stage, um, you know, re-up your objection, and especially if the case is in juvenile court and there's an adjudication and disposition, just say I'm renewing my motion that I objected to the open hearing. I'd like that be put on the record, and I'm suggesting that because there's not like a clear remedy, but if you can at least show that you made a consistent record of the concern, then it's going to be harder for the Court of Appeals to ignore that. I'm not saying they can't. I don't know because there isn't something specific in writing, but when you see something like that in the code, that's usually what you can do, is just continue to renew that issue so it maintains on the record.
Thank you so much. I appreciate that. And that one, the DA ended up taking the Class C off the table, dismissing that one so we could keep it in juvenile court. And with his age, we could do that. And we did adjudicate to something lesser. But I just generally didn't want, of course, as it started out with that sex offense. And in the future, I wanted to know if maybe I did something wrong, if I could have done something more. So I appreciate that. I just continue to object anytime it's denied. Thank you. I'm sorry, I didn't mean to interrupt.
No, you're good. Thank you for the question. So we're going to talk just a little bit about unwritten policies and procedures. You heard a little bit about this earlier. Every county has its own policies and procedures regarding appointment, notification, time and location of hearings, and hearing procedures. Just by way of example, we had a standing agreement for a while that all secure custody hearings would happen at 2 o'clock in the afternoon because of transportation issues, because we had court counselors who were short-staffed and they were just struggling to get everybody to court at 9 o'clock in the morning. So unless they fell into that category where if we didn't do it right at 9 o'clock in the morning, they were going to have to be released, we were having people brought at 2 o'clock. So make sure that you are talking to clerks, DAs, court counselors about what are the local procedures. And sometimes those are not actual written local rules. It's just, this is what we think works for our district. So this is how we handle things. So you do need to be aware of that, especially if you're planning to cover multiple different counties and you haven't been to some of the counties that the cases end up coming from. I will tell you that we talked a little bit about getting notice of appointment from the clerk, from the Department of Juvenile Justice, and sometimes from the ADA. I have had cases where I got notification that I was being appointed and a secure custody hearing was taking place because my client's parent called me and said, hey, you're appointed, you're doing this case, because nobody thought to include me in the emails or the text messages that were going around about what time are we going to do this hearing. So ideally, you're going to be notified by the clerk and you're going to be one of the first parties notified by the clerk, but maintain relationships with your clerks, with DJJ, and with your ADA's office, because they're very likely to notify you by text just to give you a heads up, hey, you're appointed on this case, if you're maintaining those relationships. Time of hearings can be set by local rules, presiding judges, the ADA, by agreement of all the parties, based on schedules of stakeholders. That's what we were just talking about. And then the hearings are informal in some districts, or they're using formal presentation of sworn witnesses in others. So even in the counties where it's largely being done right, or they're attempting to do it right by actually having testimony put on for these secure custody hearings, sometimes it's being very informal and the witnesses are not actually taking the witness stand. You need to ask for them to either take the witness stand or at a bare minimum be standing near a microphone so that what they're saying is being recorded. because all of those hearings, whenever you're appealing something, if the appellate defender contacts you and says, we need all of the hearings from first appearance forward because we're checking for all of our issues, and the person hasn't been on the witness stand and they're standing, towards a door in the back of the courtroom and just reciting something, it's very likely that the audio is going to be muffled. You're not going to hear it clearly. So make sure you're being mindful of exactly what is happening in the secure custody hearing. Push for it to be a formal hearing if you can. And then again, errors in petitions. Almost across the board, most counties that I have been to, there's been a tendency to address those errors in petitions at or near the first appearance. So be aware of that and how that might impact your client later down the line. And then again, virtual hearings, y'all obviously have talked about this. They are preferred in some districts because of staffing issues. The counties that I practice in typically prefer virtual hearings. We just couldn't do them. The technology was not working for us. You couldn't hear clearly in the courtroom. Every single time we did a first appearance and tried to handle that virtually, we would have a child who we would then go talk to them in the detention center, and they'd be like, I couldn't hear anything. I don't know what the judge said to me. I couldn't hear it. And so we would end up having to redo it. So judicial economy was not being satisfied by virtual hearings because we were having to do things twice. So be mindful of that. And then some districts are closing courts automatically. Others do it on request. There are some counties where you don't have everybody in the courtroom, partly because the courtroom space is very small and partly because they have made a decision that juvenile confidentiality matters, and those hearings are going to be just the parties. And when they're ready for the next case to come in, they're called to come into the courtroom in order, but they don't have everybody in the same courtroom at the same time. And then again, restraint hearings differ from district court to district court. Some counties basically keep everybody in restraints and bring them all in at the same time. We're doing all the secure custody hearings and you see a parade of kids come in shackled just like they are with adults. Some counties are much better at this. So again, this is know your local policies. And then the last thing that you need to familiarize yourself with is what we're calling dual jurisdiction. And these are the kids who are in the adult system and the juvenile system. So under 7B 1501, youth ages 16 and 17 charged with Chapter 20 offenses are excluded from juvenile court. And that becomes an issue when you have these kids who are charged with fleeing to elude and a string of other charges, but they've also got larceny and some misdemeanors or an assault, or they're involved with somebody who has been alleged to have committed a murder. They may actually have a first appearance in the adult system and a first appearance in the juvenile system and end up with two different attorneys. So make sure that you're reviewing the petitions closely. What information is listed in those petitions? You may be able to look at them and realize, oh, this kid's probably going to have these other charges. Talk to your DA and your court counselors and talk to the kid. Find out what kind of papers did he or she get served with, because they're hopefully going to be able to tell you, oh yeah, I've got another court date. Sometimes they just don't read the paperwork and they think that you're the only attorney. Sometimes you have a kid who looks at you and goes, why are you talking to me? Because I already talked to that other attorney. Make sure you're looking at this piece, because either you can ask to be appointed on all charges, or you can at a minimum try to work with the other attorney so that your client's getting better representation and they're not stuck with this piecemeal type of representation where they've got one attorney in one set of cases, one in another, when everything is technically related. So do be sure that you're checking those types of things. That brings us to the end of the presentation. I know Eric already mentioned first-degree murder and applying for our roster. It's actually on the website. So if you go to the website, you can find the link, pull up the application. It's a very easy process. If you have any issues or questions about it, Bersha Hensley is our main contact for that. But if you can't get in touch with her, you can contact any of us and we'll help you with the process. We need good attorneys for this, so please do consider applying.
Thanks, Terry. I did put the roster link in there. You'll also see there's a link for the evaluation, and Nani also put some general information in there as well. Well, we are at the end of our hour, but we would be glad to entertain any other questions you may have. Seems like everybody has got everything under control. That's what we like to hear. All right, everyone. Well, thank you again for attending.